Jury nullification's roots trace back to English common law, exemplified by the trial of William Penn, where jurors resisted court pressures to convict. As the concept migrated to the American colonies, it shaped early legal traditions and championed individual liberty. Influential precedents emerged during the colonial era, particularly in cases testing free speech and dissent. With the Constitution's formation, the practice evolved, informed by debates between advocates who saw nullification as a bulwark against tyranny and critics wary of undermining uniform legal standards. This dynamic journey underscores how the jury's moral conscience historically shaped both American jurisprudence and social progress. The origins of jury nullification. Few concepts within the Anglo-American legal tradition carry as much historical significance or spark as much modern curiosity as jury nullification. To trace its origins is to unearth foundational moments that shaped how laypeople came to possess the power to influence, and sometimes even reject, the statutory dictates of their governing bodies. By examining the doctrine's medieval underpinnings, formative English trials, and transatlantic transfer to the American colonies, we see how the principle of giving jurors the final say, beyond mere fact-finding, began as an ancient bulwark against state overreach and evolved into a treasured, if hotly debated, pillar of democratic legal systems. Early English common law foundations. The story begins with the development of juries in medieval England. Before juries took on their modern form, trials often occurred before feudal lords or through ordeals, such as trial by fire or water, believed to reveal divine judgment. Over time, English governance moved toward a system in which local knights and freemen, thought to be knowledgeable about community events, assessed both factual disputes and the applicability of the law. This shift laid an essential groundwork. The jury's opinion carried weight not solely as a finder of fact, but as a mechanism to inject local conscience and custom into the legal process. By the 14th and 15th centuries, the notion that a jury served as an independent arbiter was increasingly recognized. Early English common law envisioned these bodies as more than mere fact-checkers. They were local representatives, ensuring the Crown's laws did not trample established community rights. Yet, though jurors held this wide discretion, explicit references to what we today call jury nullification were rare. Judges often promoted the idea that the monarch's statutes must be uniformly applied. The tension simmered. Where did a jury's power to shape legal outcomes end? And when did it become defiance of the law? The trial of William Penn and the stirrings of jury autonomy. One pivotal moment in solidifying the jury's independent role arrived with the 1670 trial of William Penn and William Mead in England. Penn, a Quaker preacher, was charged with unlawful assembly for delivering a sermon in public that challenged the era's strict religious conformity laws. At trial, the presiding judge repeatedly insisted that the jurors return a guilty verdict, as the facts were apparently indisputable. Penn had indeed preached publicly, yet the jurors, led by Edward Bushell, famously resisted. Despite threats of fines and imprisonment from the bench, they acquitted Penn, effectively proclaiming that the law criminalizing his religious expression was unjust. The outraged judge jailed the jurors. However, the Court of Common Pleas later ruled in Bushell's case that jurors could not be punished for issuing a verdict at odds with judicial instructions. This decision underscored the principle that the jury should remain free to follow its conscience, even when it means defying the established legal order. Though not labeled jury nullification at the time, this moment stands out as a critical affirmation of the jury's autonomy in judging not only the facts, but also the moral or equitable implications of applying certain laws. Transplanting the doctrine to the American colonies. As English colonists settled in North America, they carried with them the evolving concept of the jury trial as a barrier to arbitrary governance. Local juries were often more sympathetic to the unique concerns of colonial communities than were distant royal governors or judges. Colonial charters and early state constitutions echoed these sentiments, guaranteeing jury trials as a bulwark of liberty. Cases testing free speech and dissent further expanded the role of the colonial jury. Just as William Penn's trial had done in England, certain colonial proceedings illuminated the potential for local citizens to challenge unpopular laws. One of the most renowned is the trial of John Peter Zenger in 1735. Zenger, a New York printer, had published pieces critical of the colonial governor, leading to charges of seditious libel. Although the evidence against him was ostensibly strong, he admitted to printing the offending articles. His defense argued that the truth of those articles should matter, and that punishing truthful speech was an assault on liberty. The jury, persuaded by these arguments, acquitted Zenger, demonstrating a willingness to disregard the letter of the law if enforcing it would violate broader principles of justice and freedom. Historians often cite this as a formative instance of jury independence in the colonies, a moment that would echo powerfully in later debates about legal rights and limits on government authority. The revolutionary impulse and the jury's expanded role. As tensions between the American colonies and Great Britain mounted, the jury's function as a local check on unpopular imperial statutes became even more pronounced. For many colonists, laws emanating from Parliament, such as various tax acts, were seen as infringements on their rights as English subjects. Colonial juries sometimes refused to convict individuals charged with violating these acts, either by smuggling goods to evade taxes or by publicly protesting the impositions. These acts of defiance were not universally applauded. Loyalists regarded them as anarchy in disguise, while revolutionaries hailed them as legitimate assertions of community rights. In this charged environment, the jury was a flashpoint, a space where ordinary people could either uphold or undermine the Crown's authority. By the time the Revolutionary War broke out, the idea that a jury might serve as the final safeguard against legislative tyranny had become deeply embedded in the colonial mindset. Founding-era debates and constitutional enshrinement. Following independence, the framers of the United States Constitution grappled with questions about how to design a central government that was strong enough to function, but not so powerful as to trample individual rights. Debate swirled over the appropriate scope of judicial authority, and the role of juries featured prominently. The Sixth Amendment's guarantee of a trial by jury in criminal cases reflected the belief that direct citizen participation was paramount to prevent government abuse. However, the question of whether the jury should judge merely the facts or also the law was never resolved with absolute clarity. Some prominent figures argued that the essence of a jury trial was that it empowered citizens to temper strict legal mandates when they conflicted with conscience. Others worried that encouraging jurors to ignore statutes would undermine the uniform rule of law. The resulting constitutional text neither explicitly endorses nor forbids what we now call jury nullification. Nonetheless, the jury's authority to acquit, even against evidence and law, remained a latent power, one that judges and legislators could not fully remove without undermining the entire principle of jury independence. Early American cases and the flourishing of a doctrine. In the decades following ratification of the Constitution, the role of jury nullification evolved in practice. Cases involving disputes over free speech, sedition, and economic regulation continued to illuminate the tension between law and conscience. At times, juries acquitted defendants in spite of incriminating evidence, particularly in politically charged trials where the jury perceived that the law itself, or its enforcement, was unjust. One notable episode involves prosecutions under the Alien and Sedition Acts of 1798, which made it a crime to criticize the federal government in ways deemed false, scandalous, and malicious. These acts were deeply unpopular in many regions. Some juries refused to convict outspoken critics, implicitly questioning whether the statutes were legitimate. Although not all such cases ended in acquittal, indeed, many convictions were secured. These trials underscored the friction between punitive statutes and local sentiments. The controversy eventually contributed to the act's political downfall, illustrating how jury sentiment can catalyze broader public debate and, in some instances, legal reforms. Continuity and tension from the founding to the present. By the early 19th century, the principle of jury nullification was sufficiently embedded in American legal consciousness that textbooks, treatises, and courtroom debates acknowledged it, even when disapproving of its liberal application. Judges typically instructed jurors to follow the law as given, but they lacked any formal mechanism to enforce compliance if a jury decided otherwise. Thus, the default rule in American jurisprudence became that a jury's not guilty verdict could not be overturned, whatever the motivation behind it. Even so, tensions lingered. As the country expanded and grappled with moral conundrums, most notably slavery, juror nullification would periodically resurface in dramatic ways. Northern juries, for instance, sometimes refused to convict individuals prosecuted under the Fugitive Slave Act, acting out of conscience to protect those escaping enslavement. Similar forms of resistance appeared in later eras, such as during Prohibition and in certain high-profile civil rights cases, showcasing both the constructive potential and the deep controversies that swirl around the jury's power to nullify. Understanding the origins of jury nullification is crucial for comprehending its persistent influence on American legal culture. What began as a medieval English safeguard against an overreaching crown was refined through pivotal trials, transplanted across the Atlantic, and woven into the identity of early American jurisprudence. The historical narrative reveals that, time and again, communities have relied on juries not only to establish guilt or innocence on factual grounds, but also to reflect upon the moral weight of the laws themselves. The subsequent chapters will build upon these historical foundations, delving deeper into the philosophical controversies, landmark cases, and ongoing debates that define jury nullification in contemporary practice. As we move forward, the tension between supporting the orderly rule of law and empowering ordinary citizens to act as the final arbiters of justice will come into sharper relief. Whether lauded as a democratic safeguard or criticized as an invitation to chaos, jury nullification remains a defining, if nuanced, feature of the legal landscape, rooted firmly in the centuries-old tradition recounted here. By appreciating how history shaped and sustained this doctrine, we prepare ourselves for the complexities of its modern applications. In the chapters to come, we will examine how courts, legislators, and communities grapple with a principle so deeply woven into the tapestry of Anglo-American law that it defies simple categorization. The story that began with the bold jurors of William Penn's era continues to unfold, reminding us of the powerful, and sometimes unpredictable, capacity of ordinary people to influence justice. Jury nullification in the formation of modern legal systems. Building on the exploration of the doctrine's early roots and its emergence in pivotal cases such as the trial of William Penn, we now turn to how jury nullification played a significant role in shaping the modern contours of legal systems. While the prior chapter highlighted the core concept and its initial validation in English common law and the American colonies, this chapter delves deeper into the doctrine's evolution through the 19th and early 20th centuries. In doing so, we see how jury nullification not only influenced critical legal debates, but also reflected the changing values of societies grappling with questions of governance, rights, and social order, establishing constitutional groundwork. By the late 18th century, the newly independent United States had moved to formalize its governing structures with the Constitution and the Bill of Rights. The Sixth Amendment's enshrinement of the right to a trial by jury preserved a citizen's participation in the legal process. Yet, while the Constitution guaranteed jury trials, it did not explicitly articulate whether jurors could reject the letter of the law. Across the Atlantic, England wrestled with similar questions. Though without a single codified constitution, parliamentary supremacy and case law remained paramount. In both contexts, the latent power of a jury to nullify persisted in the background, an unwritten but potent check on judicial or legislative authority. Early American courts sometimes acknowledged the possibility of jury independence. In seditious libel cases following the adoption of the Bill of Rights, jurors occasionally acquitted defendants whom they believed were simply exercising legitimate political speech, even if they technically breached statutes. Such decisions showcased an emerging recognition that the people, when convened as a jury, could interpret the moral weight of laws just as they might interpret testimony about disputed facts. Still, opinions varied widely among judges, legislators, and legal scholars over whether actively informing jurors of this power was prudent or dangerous. Tensions in the 19th century. As the new nation expanded westward and faced growing internal strains, jury nullification took on heightened significance. The tension between federal authority and states' rights, coupled with simmering debates over slavery, often erupted in courtrooms. One of the most telling examples can be found in prosecutions under the Fugitive Slave Acts, which mandated the return of individuals who had escaped enslavement. In regions hostile to slavery, particularly the northern states, some juries refused to convict those accused of aiding escapees, viewing the law itself as morally repugnant. Such acts of defiance underscored the extent to which local conscience could override federal mandates, infuriating advocates of strict legal uniformity but empowering abolitionist sentiment. Yet, the same century also saw the darker side of jury nullification in jurisdictions where racially biased jurors acquitted perpetrators of violence against minority groups. This duality highlighted that the power to nullify, while an instrument of moral conscience in some cases, could also perpetuate grave injustices when wielded by individuals guided by prejudice. The disparity between states and regions underscored a core dilemma. If the jury's verdict is final, how does a legal system prevent abuses of that power? Impact on governance and public perception. Throughout the antebellum period, the role of jury nullification was increasingly recognized as a political force. Newspapers recounted episodes of contentious trials, stirring debates over whether jury autonomy was a righteous tool for pushing back against unjust statutes or a dangerous recipe for unpredictability and vigilantism. Lawmakers grappled with demands from constituents who favored strong laws to protect social order, yet also praised jurors who took principled stands against legislative overreach. Courtroom proceedings themselves evolved under this tension. Some judges began delivering more forceful instructions that jurors must follow the law, seeking to curtail overt acts of nullification. Defense counsel, aware of the risk in openly advocating for jurors to disregard statutes, often resorted to veiled rhetorical strategies, appealing to sympathy, fairness, or broader constitutional principles without naming jury nullification outright. Across the Atlantic, English jurists similarly wrestled with the line between juror discretion and the need for legal consistency. Over time, this careful balancing act helped shape the modern trial structure, with carefully circumscribed openings, closings, and judicial instructions meant to guide, if not strictly bind, juries to apply the law. Civil War, Reconstruction, and the shifting legal landscape. The Civil War and its aftermath served as a critical period for legal transformation in the United States. With the 13th, 14th, and 15th Amendments reshaping notions of citizenship and rights, the federal government asserted new powers over states that had previously claimed near autonomy in many spheres of law. During Reconstruction, federal officials tried to protect the civil rights of formerly enslaved people, sometimes charging individuals who resisted racial equality in the courts. Yet, local juries in parts of the South often refused to convict perpetrators of crimes against black citizens, even in the face of compelling evidence. Critics of jury nullification pointed to these travesties as examples of how juror prejudice could nullify not just statutes, but the moral progress embodied in constitutional amendments. Meanwhile, northern states that had championed anti-slavery causes sometimes used the logic of nullification to stand against what they saw as oppressive federal measures to limit social reforms. This further exemplified the doctrine's versatility. It could be a vehicle for either undermining new legal protections or for asserting them, depending on the dominant sentiments of the community where a trial was held. The law itself was thus subject to evolving cultural attitudes, framed, and at times overridden, by the conscience of local jurors. Transition into the 20th century. Entering the 20th century, industrialization, urbanization, and rising crime rates posed fresh challenges to traditional legal processes. Reformers championed a more uniform system of justice, believing that consistent application of laws would reduce corruption and protect civil order. In this environment, the latitude for jury nullification became more controversial. Progressive-era activists feared that permitting jurors to selectively ignore statutes would weaken newly minted labor regulations and social welfare laws meant to protect workers and marginalized communities. At the same time, the debates surrounding prohibition laws in the early 20th century offered a striking demonstration of how public opinion could clash with statute. As the Volstead Act prohibited the manufacture and sale of alcohol, illegal production and distribution soared. In some cases, jurors sympathized with defendants accused of running speakeasies or brewing liquor in small quantities, leading to acquittals even when evidence of a violation was strong. These outcomes spurred fervent discussions among politicians, judges, and civic groups, underscoring the inescapable link between public values and jury nullification. The emergence of modern judicial instructions. To manage these tensions, courts gradually refined the process of jury instruction. A key development was the adoption of standardized language, commanding that jurors must adhere to the law, with judges reminding them that their role is to ascertain the facts and apply the written statute as explained. Defense counsel who hinted at the power to nullify risk sanctions, with judges often labeling such arguments as improper. While this judicial approach could not eliminate the underlying possibility of nullification, it did reduce its visibility. Attorneys became more cautious. They would portray a defendant's actions in a sympathetic light, aiming to evoke compassion or highlight the injustice of a given penalty, without explicitly urging jurors to defy the law. In some jurisdictions, courts went so far as to prohibit any mention of potential sentencing outcomes, fearing it might entice jurors to resist strict sentencing guidelines. As mandatory penalties and three strikes rules took hold in later decades, the question of whether juries might nullify to avoid disproportionate sentences loomed large, setting the stage for continued debate. Broader influence on democratic ideals. Even as courts attempted to formalize and control the jury process, the broader impact of jury nullification on democratic ideals persisted. Political scientists and legal theorists argued that the doctrine served as a litmus test for whether governance truly reflected the will of the people. In societies that emphasized individual liberty, the possibility of jurors ignoring an unjust or overly punitive statute could be seen as a vital safety valve. Where laws were perceived as fair and consistent with communal ethics, nullification was less likely to surface. But its lingering presence reminded legislators and judges that laws at odds with deeply held values might falter in the crucible of a jury trial. Outside the United States, some countries with jury systems mirrored these debates, while others, including several in Europe, adopted more procedural or inquisitorial models that provided judges with a stronger hand in both fact-finding and law. Nevertheless, echoes of jury nullification's function appeared in various forms, reflecting a universal tension. Legal systems strive for uniform enforcement, yet moral conviction can never be fully suppressed when ordinary citizens convene to deliver a verdict. Looking ahead, as we have seen, jury nullification has shaped the formation of modern legal systems by aligning or clashing public conscience with legislative enactments. From the early republic's constitutional framework to Reconstruction-era racial conflicts, from progressive-era reforms to Prohibition's moral crusades, the latent power of jurors to acquit against evidence has forced judges and lawmakers to grapple repeatedly with the meaning of justice. At times, nullification has facilitated social progress and highlighted oppressive laws. At other points, it has shielded bias or obstructed legitimate reforms. In the upcoming chapters, we will delve into the philosophical and ethical tensions behind jury nullification, exploring how modern courts have sought to balance the jury's authority with the need for predictability and fairness. By appreciating the deep historical roots and the ongoing controversies that shape today's practices, we gain critical insight into why jury nullification remains a point of fascination and debate, reminding us that, in a system purportedly by the people, the jury's conscience still holds transformative potential and potential perils for the rule of law. The philosophical underpinnings. In the previous chapter, we explored how jury nullification helped shape the formation of modern legal systems, reflecting societal attitudes, influencing legislative debates, and demonstrating how ordinary citizens could challenge or uphold the law. Now, we turn to the philosophical bedrock underpinning this doctrine. By examining the theories of justice, moral autonomy, and the role of conscience in civic life, we gain deeper insight into why the power of jurors to nullify has persisted in Anglo-American law. These philosophical currents, drawing on ideas from natural law, social contract theory, and notions of civil disobedience, help illuminate the delicate balance between legal authority and moral conviction that lies at the heart of jury nullification. Natural law and the moral grounding of legal systems. Centuries before the term jury nullification entered common parlance, natural law theory posited that legitimate laws must align with certain universal moral principles. Thinkers such as Thomas Aquinas and later, John Locke argued that governments derive their authority not merely from their power to coerce, but from the extent to which they honor fundamental rights and moral precepts inherent to human nature. Under this view, when a state enacts an unjust law, it effectively loses some measure of its moral authority. Applied to the jury context, natural law theory provides philosophical justification for refusing to enforce statutes that conflict with a higher moral code. In other words, if a law contravenes these universal principles, individual jurors have not only the capacity, but arguably the duty to withhold conviction. This line of thought shaped early notions of religious freedom and political dissent in Europe and later in colonial America, laying a moral foundation on which the concept of jury independence could flourish. It also informed the core idea that conscience can, and sometimes must, supersede even a duly enacted statute when that statute blatantly violates the common good. Social contract theory and civic participation. With the rise of Enlightenment thinking, the social contract model introduced by thinkers such as Thomas Hobbes, John Locke, and Jean-Jacques Rousseau further reshaped philosophical debates about law and governance. In essence, social contract theory suggests that individuals willingly surrender certain freedoms to a government in exchange for the protection of their rights. However, if the government breaks its side of the bargain by passing laws that are oppressive or unjust, citizens may justifiably resist, protest, or refuse compliance. Jury nullification offers a striking example of resistance that is neither purely private nor wholly external to the system. Instead, it operates from within the courtroom. Jurors, representing the community, exercise an oversight function on whether the social contract remains intact. If the law is perceived to violate fundamental rights or betray societal values, the jury can serve as a final moral checkpoint, declining to enforce it. Thus, social contract theory helps explain how a nominally legal structure, the court system, can embrace a mechanism by which citizens effectively veto certain applications of law. This perspective accentuates the symbiosis between civic participation and the rule of law. The very citizens who are obligated to uphold the law also hold the latent power to reject it when it conflicts with the contract's foundational principles. Conscience, morality, and individual autonomy. Moving beyond grand theories of law and state, the doctrine of jury nullification ultimately rests on the capacity of individual jurors to act according to conscience. The moral philosopher Immanuel Kant argued that moral agency is grounded in autonomy, the ability of rational beings to determine right from wrong through reason, uncoerced by external authority. In the jury setting, this translates to a juror who contemplates not just whether the facts align with the statute, but whether the statute itself meets the moral or ethical standards of a just society. This emphasis on conscience underlines the unique role of a jury in a criminal trial. Unlike judges or prosecutors, who are generally bound to enforce the law's letter, jurors occupy a liminal space. They take an oath to well and truly try the case, but no mechanism forces them to convict if they conclude that a guilty verdict would be morally reprehensible. Where conscience dictates, they may refuse to enforce the statute. Such a refusal, while controversial, is intrinsic to the notion that the law ultimately must answer to ethical judgment, lest it become an empty instrument of power divorced from justice. The influence of civil disobedience. It is important to note that jury nullification shares certain philosophical roots with civil disobedience, a concept popularized by Henry David Thoreau, Mahatma Gandhi, and Martin Luther King Jr. Civil disobedience involves the deliberate and public refusal to obey laws perceived as unjust, undertaken with the intention of prompting legal or social reform. Though nullification occurs within the confines of a court trial rather than a protest march, the underlying moral logic is similar. Individuals must not blindly comply with unjust statutes. Instead, their actions or verdict may call attention to the injustice itself. However, key differences distinguish jury nullification from classical civil disobedience. First, jurors do not typically suffer punishment for acquitting a defendant. By contrast, civil disobedience often accept the legal consequences of their defiance. Second, civil disobedience is public and openly confrontational. Jury nullification can be discreet or even hidden, occurring through the privacy of jury deliberations. Still, the philosophical thread remains. Both practices rest on the conviction that moral righteousness can, and sometimes must, override formal law, balancing morality and legal uniformity. Critics of jury nullification question whether it undermines the principle of equal treatment before the law by allowing subjective moral judgments to trump consistent application of statutes. From a utilitarian standpoint, legal philosopher Jeremy Bentham prioritized societal happiness and order, arguing that unpredictable applications of law breed uncertainty. If every jury can rewrite the law on moral grounds, the critic contends, the result may be legal chaos. Against this, defenders of jury nullification point to instances throughout history, slavery laws, draconian punishments for minor offenses, oppressive speech regulations, where the formal law lagged behind evolving moral consensus. They assert that if laws are truly out of step with communal values, the jury's power to nullify can spur legislative reform or serve as an emergency brake on government overreach. In this sense, the tension between moral autonomy and uniform legal application is precisely what makes jury nullification a dynamic, though at times uneasy, feature of Anglo-American jurisprudence. The role of the community and cultural context. Jury nullification also implicates the broader question of whose morality the jury represents. In a pluralistic society, moral values can vary sharply across regions, communities, and demographics. One community might consider a prohibition law unfairly punitive and thus refuse to convict, while another, viewing the same statute as crucial to public morality, readily enforces it. This phenomenon highlights how nullification can be a barometer of local sentiment, reflecting cultural contexts that may differ from the official stance of a legislature or judiciary. At the same time, racial or class bias has historically colored jury decisions, bringing forth troubling examples where nullification perpetuated discrimination rather than challenging it. Thus, while the philosophical ideal might posit that conscience-driven jurors resist only those laws that violate fundamental justice, the real-world application can veer in darker directions. The tension between the ideal of moral justice and the reality of human bias underscores the significance of robust jury selection procedures, judicial guidance, and public awareness of the principles at stake. Modern reflections and ongoing debates. In many current discussions, the philosophical arguments supporting jury nullification pivot on a desire to protect minority rights or to alleviate disproportionate punishments. Advocates may cite cases where mandatory minimum sentences for nonviolent offenses seem unjust, arguing that conscientious jurors have the moral authority to acquit, effectively objecting to draconian penalties. On the opposite side, critics warn that sanctifying a moral veto to every juror risks fracturing the rule of law into pockets of arbitrary decision-making. Ultimately, the philosophical underpinnings of jury nullification reveal a constant interplay between moral reasoning, community standards, and formal legal structures. Whether one views the doctrine as an essential safeguard or a threat to uniform justice, the enduring debate attests to the vibrancy of democratic societies that invite citizens into the process of administering law. It also forces us to grapple with the notion that law is not merely a set of written rules, but a fluid social institution shaped by human judgment, empathy, and indeed, conscience. Having delved into the philosophical roots of jury nullification, spanning natural law, social contract theory, moral autonomy, and civil disobedience, we now have a deeper grasp of why juries have the capacity to deviate from straightforward legal application. In the next chapter, We will explore how these philosophical currents manifest in modern legal contexts, including the ways courts have responded to the ethical complexities raised by nullification. By linking these historical and theoretical threads to real-world courtrooms, we gain insight into how this concept continues to provoke debate, spark activism, and influence the trajectory of legal reform. Legislative case studies. Building on our exploration of jury nullification's philosophical underpinnings, we now turn to how this principle has influenced legislative formation at the state level. Throughout American history, lawmakers have encountered the reality that juries sometimes refuse to convict under laws deemed immoral or unjust by local communities. In response, different states have experimented with varied statutory frameworks, court instructions, and procedural rules designed either to harness or to curb jurors' capacity to nullify. By examining these legislative case studies across multiple jurisdictions, we gain insight into how localized values can shape the delicate balance between formal statutes and the moral conscience of citizen jurors. These examples also illustrate the ebb and flow of legal reform, including attempts to reconcile uniform enforcement of state laws with the persistent undercurrent of community-driven verdicts. Early legislative reactions in the Northeast. In the northeastern states, particularly Massachusetts, Pennsylvania, and New York, legislative bodies confronted jury nullification from the earliest days of the Republic. Pennsylvania, for example, was home to William Penn's famous 1670 trial in England before he emigrated, thus symbolically linking the colony's legal heritage to the concept of juror independence. After the founding of the United States, Pennsylvania's legislature was among the first to consider laws concerning judicial instructions and the scope of the jury's role in both civil and criminal trials. While no statute explicitly authorized jurors to disregard the law, the framing of early procedural codes reflected an implicit respect for the principle that jurors might judge both fact and law in certain high-profile prosecutions. Massachusetts, heavily influenced by the legacy of the Salem witch trials and subsequent introspection about miscarriages of justice, showed a measured approach to the jury's power. Early legislative reforms centered on ensuring that jurors understood the specific charges and relevant legal standards, without overtly banning the idea of conscience-based acquittals. Some legislators believed that providing a clearer legal framework would minimize misguided or prejudiced uses of nullification, while still preserving space for moral reasoning if laws conflicted with a community's sense of equity. By contrast, New York's lawmakers grappled with the memory of John Peter Zenger's seditious libel trial, which ended in acquittal despite seemingly clear evidence of guilt under the statute. This case weighed heavily on New York's approach to drafting press freedoms and libel laws, recognizing that juries, not just statutes, could effectively shape the boundaries of free expression. Southern states and the influence of slavery. In the Southern states, legislative attitudes toward jury nullification became deeply entangled with the institution of slavery. Prior to the Civil War, many Southern lawmakers enacted strict codes to protect slaveholding interests. However, Southern juries often delivered conflicting signals. In some cases, they were zealous about convicting individuals assisting freedom seekers, while in other localities, strong community ties might shield certain defendants from conviction. The variation across counties and states revealed how local sentiment could defy uniform legal mandates. Louisiana, for instance, had a unique legal tradition due to its roots in French civil law fused with American common law. This distinctive mixture sometimes created procedural gaps that allowed jurors to exercise wider latitude. While state legislators worked to codify criminal procedures to ensure convictions under slave codes, certain parishes displayed strong local allegiances that led to unexpected acquittals or lenient punishments, prompting legislators to pass more stringent laws in an attempt to curb perceived jury inconsistencies. In Georgia and Alabama, discussions in legislative sessions often revolved around how best to guarantee convictions in runaway slave cases, with some officials proposing mandatory jury instructions that left no room for extra-legal sympathies. Despite these measures, the moral undertones of local communities could still emerge in surprising verdicts, foreshadowing the tension that would explode nationally during the Civil War era. Post-Civil War Reconstruction and divergent paths. After the Civil War and into the Reconstruction era, Southern state legislatures were forced to revisit their criminal codes and jury procedures, particularly as the newly ratified constitutional amendments aimed to protect the rights of freed people. During this period, federal laws and amendments clashed with entrenched local sentiments in many Southern legislatures. Some legislators attempted to craft statutes that would secure convictions against perpetrators of racial violence, recognizing that local juries, infected by bias, might nullify even in cases of serious crimes against black citizens. Mississippi and South Carolina illustrate two divergent paths. Mississippi's post-war legislation tried to maintain tight control over jury selection, hoping that predominantly white juries would uphold local customs even if federal troops oversaw elections and limited legislative sessions. In such an environment, racially motivated nullification was common, allowing violent offenders to walk free despite the official stance against such crimes. By contrast, South Carolina's Reconstruction government, briefly dominated by more progressive lawmakers, enacted legislation aimed at broadening jury pools and strengthening legal protections for the newly emancipated. While this did not explicitly reference jury nullification, the hope was that a more representative cross-section of jurors would be less likely to acquit perpetrators of racist violence. Over time, though, the rollback of Reconstruction reforms and the rise of Jim Crow laws meant that legislative efforts to curb discriminatory nullification lost momentum. Western states, frontier pragmatism and legislative innovation. As the American frontier expanded westward, newly admitted states grappled with forming legislatures that would codify their own criminal and civil procedures. States like California, Texas, and Colorado each confronted distinct issues, ranging from land disputes and cattle rustling to vigilante justice. Jury nullification factored into many legislative conversations, sometimes quietly, sometimes overtly, as lawmakers recognized that frontier juries held strong local allegiances and might ignore laws imposed by distant state capitals. In Texas, for instance, early legislatures debated whether to create explicit statutory provisions requiring judges to inform jurors of their duty to follow the law strictly. Rural communities, however, were often sympathetic to defendants facing what they deemed unreasonable statutes, resulting in frequent acquittals. This tension led to legislative efforts to penalize juror misconduct, though these laws remained largely unenforced. Meanwhile, California's gold rush era saw an influx of diverse populations and a spike in crime, prompting numerous legislative experiments. Some counties even established hybrid tribunals or people's courts that resembled official juries, but wielded broad discretionary power to determine guilt or innocence. Such experiments underscored the West's ongoing attempts to balance the formal rule of law with the on-the-ground realities of rapidly changing communities. Reform movements and progressive-era statutes. By the late 19th and early 20th centuries, progressive reform movements swept across many states, especially in urban centers. Fueled by concerns about corruption, unethical business practices, and health and safety violations, reformers sought to pass robust statutes regulating everything from food production to labor conditions. Yet, as these new laws took effect, legislatures encountered pockets of resistance in certain regions where communities were reluctant to punish local business owners or neighbors. In some instances, these communities engaged in implicit jury nullification, acquitting defendants who technically violated new regulations. New Jersey and Illinois provide illustrative case studies. Reform-minded legislators in both states championed measures to tackle social ills, ranging from child labor laws to sanitation codes. However, some rural or smaller urban communities perceived such regulations as burdensome, out-of-touch mandates from distant capitals. In response, local juries sometimes acquitted offenders, effectively nullifying progressive legislation. Attempting to shore up the new laws, legislatures in both states introduced more precise statutory language, stiffer penalties, and mandatory minimum sentences, hoping to dissuade juries from taking matters into their own hands. Ironically, those same measures at times fueled more sympathetic reactions from jurors who disagreed with harsh punishments, perpetuating the cycle of acquittals. The Prohibition era and state responses. The era of national prohibition, 1920 to 1933, offers perhaps the most iconic example of widespread jury nullification influencing legislative debates. While prohibition was anchored at the federal level by the 18th Amendment and the Volstead Act, enforcement depended heavily on state-level statutes and local juries. Almost overnight, states scrambled to pass or revise laws regulating alcohol possession, distribution, and consumption. In many locales, juries refused to convict bootleggers, speakeasy owners, or individuals caught with small amounts of liquor, undercutting the entire legal apparatus. States like Michigan, Ohio, and West Virginia, where temperance sentiment had been strong enough to elect lawmakers supporting prohibition, soon discovered that their own constituents were reluctant to punish neighbors for engaging in formerly legal behaviors. Legislative sessions became embroiled in debates about whether to escalate enforcement with stricter penalties or to concede that popular opinion was not aligned with the official stance. Some states instituted minimum sentences or allowed for special enforcement courts, in which jury trials were more limited. Yet these measures often backfired, either riling public opposition or simply driving alcohol-related offenses further underground. The patchwork of state-level responses to prohibition ultimately underscored how crucial jury verdicts can be in turning the tide against laws that lack broad public support. Mid-century shifts and civil rights legislation. From the 1930s through the 1960s, American society underwent dramatic changes, including the rise of the civil rights movement. For many Southern states, legislative reforms aimed at dismantling overtly racist statutes were overshadowed by the persistence of racially biased nullifications in state courts. African Americans were often excluded from jury pools, perpetuating skewed outcomes in trials involving racial violence. Even as the Supreme Court gradually intervened to enforce equal protection in jury selection, some state legislatures passed new statutes designed to sidestep federal rulings, making it more difficult for African Americans to serve on juries or even to register to vote. Simultaneously, northern and western states faced their own challenges. In states like Illinois and California, emerging civil rights statutes outlawed discrimination in housing and employment. Communities that resented these reforms occasionally saw local juries acquit offenders charged with violating anti-discrimination laws. Legislatures in these states tried to strengthen prosecutorial tools, authorizing civil as well as criminal remedies. While civil actions eliminated the jury's role in deciding guilt or innocence, criminal penalties still required a jury trial. Thus, the tension between newly minted laws and jurors unwilling to convict remained a stubborn feature of the legal landscape. Late 20th century trends and mandatory sentencing. The latter half of the 20th century witnessed the proliferation of mandatory sentencing guidelines, three-strikes laws, and an intensified war on drugs. Lawmakers, responding to concerns about rising crime, sought to constrain judicial and juror discretion with rigid statutory penalties. Yet these very measures at times spurred a renewed interest in jury nullification. If a juror believed a mandatory sentence was unduly harsh, especially for nonviolent or low-level offenses, they might opt to acquit rather than see a defendant's life ruined by severe punishment. States like New York and California took center stage in debates about mandatory sentences for drug-related offenses. Legislators hoped that stiff penalties would deter crime, but as stories circulated about first-time offenders facing decades behind bars, some juries rebelled. Acquittal rates in certain drug cases began to climb, suggesting that moral sentiment could override a law's ostensible clarity. In turn, legislators introduced even more specialized enforcement measures, such as drug courts and plea bargaining incentives, to circumvent the unpredictability of jury verdicts. This interplay between legislative rigidity and jury conscientiousness speaks to a recurring theme. Whenever laws substantially diverge from prevailing moral values, nullification tendencies can resurface, confounding lawmakers' attempts to control legal outcomes. Persistent divergence among the states. By examining these historical case studies, a pattern emerges. No single approach has entirely resolved the tension between legislatures that wish to uphold uniform statutes and the jury's power to nullify. State by state, experiments with stricter jury instructions, changes to voir dire rules, and the enactment of harsher penalties have all met with mixed success. In some states, like New Hampshire, there have even been contemporary legislative proposals to explicitly acknowledge the jury's right to judge the application of the law, though such measures have generally faced resistance from the bench. Meanwhile, states like Colorado and Montana have seen grassroots pushes to require courts to inform jurors about their power to deliver conscientious acquittals. Critics argue that making nullification explicit would undermine the rule of law, while proponents insist transparency is vital for democratic accountability. These ongoing disputes reflect the diverse attitudes toward jury nullification across the American landscape, shaped by local history, political culture, and the very real experiences of legislative triumphs and failures. Taken together, the legislative case studies reveal how deeply jury nullification has influenced and been influenced by state-level lawmaking. From early colonial codes in Massachusetts and Pennsylvania to the post-Civil War statutes of Mississippi and South Carolina, from frontier justice in Texas and California to progressive-era reforms in New Jersey and Illinois, legislatures have consistently wrestled with the quandary of reconciling official statutes with the moral judgments of local juries. This tension has periodically produced innovations in jury instructions, trial procedures, and sentencing schemes, reflecting each state's evolving strategies to channel or constrain juror independence. As we move forward, we will examine how these historical precedents intersect with modern challenges, such as mass incarceration, emerging social movements, and the digital age's impact on public opinion. We will also compare American experiences to jury systems in other democratic nations, asking whether jury nullification is an inevitable byproduct of citizen participation or a uniquely Anglo-American phenomenon. Understanding the legislative struggles chronicled in this chapter helps us appreciate the broader context in which contemporary debates unfold, revealing the long arc of tension between the written law and the silent, potent authority vested in a jury's conscience. In the next chapter, we transition from legislative explorations to a deeper look at the courtroom itself, how judges, prosecutors, defense attorneys, and jurors navigate these legal structures in real time, and how nullification factors into everyday practice. By linking state-by-state legislative developments to the practical realities of trial procedure, we will see how the themes of history, philosophy, and local governance converge in the crucible of a criminal trial, where ordinary citizens still hold the power to alter the course of justice.